The case of Hunter against Hanley.
Session cases of 1923, page 105.
When judges began recording their own decisions in the 16th century, they were producing the precursors of modern law reports.
The unlimited sovereignty of Parliament is a distinctly English principle which has no counterpart.
Whether they wrote their decisions down primarily for posterity or to aid the consistency of their decision-making, we cannot be sure.
Was a passenger in a tramway car which was proceeding in the direction of Collington.
But as the hearing of cases became more formalised and law reporting more structured, a doctrine of precedent arose.
Which was given for something, but for which nothing was got in return.
What precedent means to me really is the idea that there are decisions of higher courts which will be binding on lower courts.
Precedent is a different sort of law to statute or legislation. Legislation is made by Parliament and interpreted by judges. Precedent is judge-made law.
The court has to search for the principle underlying the area of law that's being applied, and precedent in the sense of cases decided on a similar issue, either a similar legal issue or similar factual issue, will help guide that decision.
And underlying most of Scots law, I think, is a desire to try and maintain the principle and to work out the principle behind what we're doing.
It's a fundamental principle of justice that like cases should be decided alike and different cases should be decided differently. And so what precedent gives us is a store of the way previous cases have been decided.
My Lord, turning now to the case of Donoghue against Stevenson. This was reported in the 1932 volume of Session Cases.
Donoghue and Stevenson established a really important principle in the law of delict, as it's called in other jurisdictions, tort.
This case regarding the decomposed snail in the ginger beer bottle.
Donoghue and Stevenson provides really the foundation of the modern law of negligence.
And because it was decided in the House of Lords, it established that principle not only for Scotland, but also for the rest of the United Kingdom and indeed for the Commonwealth.
Donoghue against Stevenson was a majority decision of the House of Lords. The judges disagreed as to the outcome. Lord Buckmaster gave the main dissenting opinion for the minority, but for the majority, it was the opinion of Lord Atkin that has resonated subsequently with lawyers and judges alike, and upon which the modern law of negligence is based.
The liability for negligence, whether you style it such or treat it as in other systems as a species of culpa, is no doubt based upon a general public sentiment of moral wrongdoing for which the offender must pay. But acts or omissions which any...
It was a majority decision in the House of Lords. You'll see contrasting styles of how the different judges used previous decisions, how they used precedent.
The rule that you are to love your neighbour becomes in law, you must not injure your neighbour. And the lawyer's question...
What Lord Atkin appears to have done is to have said, well, what is the principle underlining all these other cases in which recovery was allowed or not allowed? And that's when the neighbour principle was developed.
Now that principle, stated for the first time in that way by Lord Atkin, has been applied in numerous subsequent cases and is the foundation of the current law of delict, and represented quite a significant departure from the approach which had applied up to then.
Who then, in law, is my neighbour? The answer seems to be persons who are so closely and directly affected by my act that I ought reasonably to have them in contemplation as being so affected when I am directing my mind to the acts or omissions which are called in question.
That's judicial writing of a very high order, and it's perhaps for that reason also that the case has come down. The principle is clearly stated, but it's elegantly stated as well. Lord Buckmaster in Donoghue and Stevenson applies a more traditional approach to precedent.
Lord Buckmaster sees decision favourable to Mrs Donoghue, and he distinguishes it by saying, well, that seemed out of step with other decisions and it's lived a very dangerous life and its dubious holding should just be put to bed now.
And it was also combined with what one very often has whenever the challenge is to move onwards from the strict area of precedent, the floodgates argument. And you can see the floodgates argument weighing very much with Buckmaster.
There's come to be a recognition as the law has developed that taking too rigid a view of precedent means that the law doesn't adapt to meet changing circumstances.
One of the difficulties about precedent, which is if you apply it too strictly, you can't develop the law. So there has to be some inbuilt flexibility.
Sometimes, due to changes in society, the criminal law needs to develop and precedent be overturned.
In Scotland, we have a common law system of law, and it's often described as a live system of law. And whilst you look at precedent, the court might determine that precedent shouldn't apply in a particular situation because there have been societal changes. And a really good example of that occurring is when the Court of Appeal in Scotland looked at the law of rape in the Lord Advocate's reference number 1 of 2001, when they changed the definition of rape in order to bring it up to date and take into account the change of women's position in Scottish society.
Whichever court an advocate appears in, however, for precedent to be applied, a record of previous cases needs to exist.
As an advocate, it's really important that one refers the court to the cases that matter. And what one looks for in a good set of law reports is that the editor has made the first cut.
Cases which develop the common law, cases which explain statutes, cases which resolve areas of doubt.
And that's really what law reporting is all about, to enable people to see ideas in action. They don't have to agree with them. They may try to distinguish them. They may decide that they're wrong. But it's helpful to know that the ideas are out there and that people have the opportunity to read them if they choose.